stay tuned in case I think there are a couple doubly referred bills that if the other committee passes them and comes to us, then we may have to do that. But we'll have to wait and see about that. So the first one we'll call up, I don't see Senator Boyd, so we're going to call up House Bill number 70. This is the autopsy bill. We do have a strike all that is on the way, which would put Senator Boyd's language that we had already passed back into the bill. And I think Senator Sparks has a sort of a refresher on what that entails. So if he'll explain that to us. I'm told the strike all copies are literally minutes from being here, right, Pat? They're on the elevator. So by the time he finishes explaining, hopefully we'll have a hard copy in front of you. All right, Senator Sparks.
Thank you, Mr. Chairman. This bill, and I know we've had a lot of discussion. I think most members of the committee are very familiar with it. Senator Boyd did have a version, and I'm sure there's a lot of similarities, but the easiest way would be to just go ahead and strike all as has been recommended. This was a bill that would prevent the display and inappropriate display of autopsy photographs, things that happened particularly in a case in the Meridian area, that if you have access to these things, it ended up in online, and we've had 48-hour shows about it. That's not the purpose of autopsy photos. They are investigative in nature, and they need to stay in that manner. And so that's what this bill does, is that it keeps it confidential to the extent legally possible. Of course, obviously through discovery and other mechanisms, we're not limiting anybody's rights as it relates to that. It is the commercial display, I guess you will, of autopsy photos. But I would yield any questions, Mr. Chairman.
Okay, and this sort of derived, I understand, from a situation maybe over in East Mississippi. That's where
correct. Yes.
Some pictures from autopsies got displayed on the internet or on a podcast or something like that, and caused the family a great deal of distress, as you can imagine. So that's the genesis of this bill. And I think hopefully we all now have, I think they already have that one, hopefully the copies in front of you. So any questions for Senator Sparks on his strike all? Senator Simmons.
Thank you, Mr. Chairman. As the bill was presented as a Senate bill, I just wanted to make sure we still have the language in it that will not prohibit criminal or administrative proceedings from actually carrying on their duties as it relates to this type of material.
That's my understanding, right? Yes, and it also still maintained the amendment. I think there was an amendment where we named the bill.
That's correct.
For
Christian Androkis,
the family and the gentleman that was victimized by this. All right, any other questions? If not, for a motion?
Title sufficient to pass strike all.
As amended.
As amended, perfect. All right, you've heard the motion. All in favor say aye.
Aye.
Any opposed? Nay. The ayes have it. And I understand Senator McDaniel is joining us as well. So if Senator McDaniel, if you need to ask a question or any of that kind of stuff, please let us know. I'm not sure how you would go about doing that, but can you hear us, Senator McDaniel?
I'm here. Can you hear me okay?
Yeah, we may need to cut you up a little bit. It's kind of light, but we do hear you. So just scream out or whatever you need to do if you need to ask a question or offer any amendments or anything like that, please, sir.
Yes, sir. Thank you very much.
All right. The next bill is House Bill number 287. This, again, there is a strike all. So you actually have two packets. You have the packet with the original language as it passed the House on the thicker packet, and then the strike all packet, you have what we're proposing in the strike all, which is basically Senate language. But this bill, we're taking certain provisions of what the original bill does out of the language and replacing it with what? Ethan, if you can give us, I think, better names of different things.
This is the House bill that came over to us, and it just basically standardizes references to the intervention courts that are referred that way in the statutes, and it changes them to be referred to as drug intervention courts. Just kind of a cleanup technical bill. And then in the definitions on lines 68 and 70, you'll see that it defines research-based program and evidence-based program. And then it requires, it implements the drug intervention courts to make sure that they're, the programs that they use are research-based and evidence-based.
And the names that were changed, can you give us some ideas of what the names used to be in the current law versus what the name we're changing it to now?
Like mental health court or a veterans court, they'll just be referred to as the drug intervention courts now.
So you won't
One
say mental
umbrella.
health, so you'll say the drug intervention courts.
Right.
Okay. I believe those are the only changes. Now, anything we're leaving out of these were sort of all brought to us last minute, but we're doing the best we can with all of these. I believe the other main issue that we had as the bill came to us, and some of y'all had spoken to me about this, is there were code sections put in that bill originally in the House, and I think even language originally, and then the language maybe was taken out, but the code sections left that would be able to add or reconfigure certain judicial districts. Apparently there was a desire in North Mississippi on behalf of maybe the House member that brought this to us to separate some counties out from the district and add other judges and those sorts of things. And what I told Chairman Bain was, this is really not the method for doing that. We have judicial redistricting bills that come along ever so often, and those are the proper format for changing judges and adding districts and those sorts of things. So the strike all in the Senate strike all before you takes out all those code sections. So if this were to go to conference, those code sections to rearrange judicial districts would not be present before us. So that is the other significant change that I wanted you to know about on 287. So with that explanation by our esteemed council, any questions about any of the language in the strike all? Senator Hill. Okay, so excluding burglary of an unoccupied dwelling on 548 and 549. Yes, that is new language. Ethan, what does that do for us? Okay, Senator Sparks.
Thank you, Mr. Chairman. I believe that it distinguishes unoccupied dwelling from dwelling, and that's really so the DAs can work as well as the judges to say, look, this was by fact an unoccupied dwelling, although we don't have a crime that says unoccupied dwelling. It's all home burglary. So I think it's a tool they want to use to determine as far as severity so that they can decide whether someone needs to participate, because a lot of the break-in and theft that occurs is from somebody who's an addict. But of course, I think if the court and the DA's office determines that this person, that's not the issue, or there was occupied folks at the dwelling, because I've had this with houses that are abandoned, that there's a break-in, but because it's a home, not a commercial building, it's home burglary, even though it's not occupied. So I think that's the differentiation.
But Senator Hill is correct that this would, if this language was adopted, then you would have additional crimes that would be able to be as part of the intervention court.
That is correct, Mr. Chairman.
Okay. Now, the other question I would have is, does the perpetrator know in these instances that the property or the home was unoccupied?
And that I obviously wouldn't know, but I think the DA has to make an offer for someone, or a judge has to determine for someone to receive it. We're just saying we're not going to exclude you if the facts, the circumstances, and the evidence show that it was not occupied, and they want to make that offer to put you into intervention court or drug court, that they would have that option, which they do not have today because it's forbidden by statute.
Senator Simmons?
And I'll, Mr. Chairman, if I can add,
Sure.
And to Senator Hill's question, there are a lot of situations where people are drug addicts and they basically are homeless. So you'll find the person basically addicted to a drug in a vacant building, a vacant home. And because it was a home, no one was injured, no one was there. And you want to drug court, and the DAs want to have the option to basically address the drug addiction. And so according to our current statutes, house burglary of any kind is basically prohibited for drug court. What this does is carves out just the narrow situations where they look at it as a property crime, because other property crimes are allowed in drug court, but crimes against persons are not.
Right.
And so when the home is occupied and you put someone at fear, You still can't get in drug court. We are not changing that. The only thing is in those rare situations where someone is actually in a vacant home or an abandoned home and they are basically there because of a drug addiction, the drug courts as well as the prosecutors just want to have that option to consider them. It doesn't mean they're going to get into drug court, but just to consider them for drug court
As a candidate.
as a candidate. Yes, sir.
All right. Senator Hill, did that answer your question? All right. Any other questions? Very good questions and answers there. If not, for a motion, Senator Sparks.
Title sufficient to pass, strike all, or
As amended.
As amended. Very good. I get confused on that every time too.
Yeah.
All right. So as amended, you've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. All right. Thank you all for that. All right. Going on down to House Bill number 290, pretrial intervention prohibits certain amount of public embezzlement for. You'll remember this was a bill the state auditor's department had asked for, and it deals, I believe, with a public official who has embezzled $10,000 or more, and we were saying that those persons would not be able to go into pretrial intervention. If it's less than $10,000, it would. So the language that we have before us in the strike all is, I believe that was Senator Sparks' language.
Yes,
Would you just reiterate that and make sure we said
Yes.
it correctly?
Thank you, Mr. Chairman. This was a bill that was requested by the state auditor, and it's only public funds. If you have embezzled public funds in a role as a public employee or public funds in excess of $10,000, you cannot go into diversion. One of the things we have to realize is embezzlement is not one of the items that can be expunged. But in a pretrial diversion situation, your case after completion was dismissed and expunged. So if you non-adjudicated it, you couldn't get it expunged. If you go through pretrial, you could. So it was an inequity. And so we thought the $10,000 cap was reasonable. So if you've stolen public funds over $10,000, you cannot have a pretrial diversion, which would ultimately make you able to go back into the public sector again and handle money. That was what the state auditor wants to prevent.
Okay, and I understand the difference between the House version, which was very close to the same thing, was what?
We were just a little more specific with the references to the statute section 97.711 and 97.1131 at the request of the auditor.
So essentially the bill did the same thing. We just got a little more specific at the auditor's request with the specific code sections that maybe didn't appear in the House.
That's correct.
All right, questions? Senator Simmons.
Yes. What's 97-711?
One, I'm sorry.
Go ahead.
One deals with embezzlement as a statute. The other deals with obtaining goods by fraud. So you either physically took the money or you obtained them fraudulently, which are both thefts of public funds. That's the two different statutes.
Okay, Senator Hill. Yeah, this is the proper time. Well, now these are public funds, I think. So I don't know of a scenario. Do y'all know of a scenario where that would? Yes, it's a public official. Okay, good thought then. Thank you for that. All right, any other questions? All right, if not, Senator Sparks for a motion.
Title sufficient to pass, strike all.
As amended. All right. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Very good. All right. House Bill number 551. Our strike all is basically our driver's license reentry language that I'll ask Senator Sparks if he will just refresh us on what that specifically does for us.
Our driver's license, thank you, Mr. Chairman. The Department of Public Safety, working in conjunction with the Department of Correction, is ordered, not authorized, but ordered to determine the driver's license history of someone who comes in to the Department of Corrections, allow them to know what issues are there so they can try to fix that while they are incarcerated. The goal is that they would actually have a regular operator's license upon exit from the Mississippi Department of Corrections so that they immediately are able to travel to pursue job opportunities. In the event that they're not eligible for a regular operator driver's license, we want to give them a provisional driver's license for a 6-month period of time that will allow them to, again, travel to clean up any issues they have outstanding in courts. And of course, we're encouraging our courts to work with them to work payment plans and et cetera. We will not give a driver's license to someone who cannot have it because of a driving under the influence charge that violates some other law or a compact agreement that would impact NHTSA rules, but we will give them an ID. Now, the last case scenario is that if we do not have birth certificate or social security documentation, we cannot give out a gold star type of identification so that you can fly without proof of who you are. So the last option is we give you some form of identification that would allow you to, pursue those jobs, but we couldn't do something again that would violate federal law. But the goal is to make sure everyone leaving the Department of Corrections has a proper ID that's preferably not an MDOC ID. It is a state of Mississippi issued driver's license, provisional driver's license, or ID.
And this is just to allow, from a workforce development type standpoint, allowing people that have previously been incarcerated that are now back trying to integrate to society to be able to get a job.
That's correct. And so,
productive.
yeah, that's correct, Mr. Chairman. And so many of the people that are coming out are going to continue to be under supervision. So they're going to have to meet with their probation officer or their parole officer. And of course, with our reentry courts, we hope that that passes and gets signed into law, that they would actually have it to travel to the reentry courts and be gainfully employed. And as is a requirement of probation or parole, is that you are employed or you are seeking education or a caregiver.
Sure, because there are already plenty of impediments to them getting a job anyway. We don't want the fact that they can't legally drive from home to work to be another one of those. Okay.
Sure.
Other questions, comments about that one? All right, Senator Sparks for a motion.
Title sufficient, do pass, strike all as amended.
I think just as amended, right?
All right. Oh, I'm sorry. Okay, thank you.
Just as amended.
I'll get it right if I
You'll
get
get it.
all
That's okay.
9 of them. I'll try, Mr. Chairman.
All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right. House Bill number 615, the DUI suspension, clarify how the 120 days are counted. Now, what I understand on this one, there's been some confusion as to when these 120 days are counted. And I'm sorry, there's no strike on this one. We're leaving this one as is. So if you're shuffling through the other packet, there's not going to be one. It'll be in the thicker packet. So what this bill does currently is it states that the 120 days starts from the day that the judge signs the order. So that is day one, and then the 120 days are counted from there. Now, I understand for some of those of you who may have practiced this type of law, which I do not, Senator Simmons or others, is that an issue that needs to be addressed?
Yes, sir. But I do have an amendment at the appropriate time.
Okay. So where's the confusion?
So the confusion is, a lot of times people will get pulled over, they'll get cited for DUI, and the question is, in some instances their driver's license may be taken, or they may be given just a ticket or to indicate that they've been cited for DUI. And the question is, does the 120 days time for suspension start at the point of the stop, or does it start at some later point when you go to court and the judge now adjudicates you guilty of DUI?
Okay.
And so a lot of times by the time you go to court and you get adjudicated by a judge guilty for DUI, so much time has passed prior to the time of the stop and the time you go to court.
Right.
So it would be more than 120 days, but you just want some kind of uniformity. So I think that the goal is try to make sure it's clear when the clock starts. But for those reasons, at the appropriate time, my amendment would be
Sure.
to put a reversal killer in it.
I think it already has
Okay,
one.
no problem.
I believe it has one in
No
there.
problem. Okay.
But I just wanted to get to, because I've never practiced any DUI law. So for those of us like me and others that maybe don't know the vagaries of the law, I wanted to make sure this was really a problem that needed to be addressed. And y'all think it is? Okay. All right. Senator Super.
Going with what Senator Simmons is saying, a lot of times when people are pulled over, they get the little pink sheet or whatever. That's only good for 30 days, and the judge actually has to sign an order extending their driving privileges until they go to court. If that doesn't happen, their license will be suspended. You might not have court for 6 months. And so their license gets suspended, then they go to court, and then they get suspended again. And, I'm like you know, I know Senator Sparks and Simmons both practice criminal law, and you know, and I have for a long time. But I like to see some kind of clarity in that, because I can't find in the statute why though. And they say it's administrative suspension. I've never figured out why it's being suspended, because you know there are people who are innocent. You know, when they are pulled over. I mean, you know, a lot of them are not, but you know, I think that's a determination for a judge, and so I'll be.
We all look at the language of this and make
Yeah,
sure it's what we need.
right,
If
I'd
not,
like
it has
to-
reverse repealer in it, so it's got to go to conference. We can certainly still tweak on it.
Yeah, I know. I'd like to help on that, because I know
All right.
we've got a problem, and you know, I'd like to fix that.
All right, Senator Turner, forward.
Thank you, Mr. Chairman. And my question goes to the issue that's been raised by Senator Suber and Simmons.
Mhm.
Are we going to perhaps delete the authority for an administrative suspension and then allow the judge to suspend if necessary if one of these instances occurs where the officer believes that the person needs their driver's license suspended immediately? I think that's where the overlap is coming. I don't know where this authority is for the administrative suspension. And I'm just wondering if it might be best to remove that authority.
Senator Suber.
Well, I know there is an administrative suspension for not refusing to blow the machine. You know, and I don't know if we want to change that or not, but my problem is, and you know, one of the biggest things I've had when I was a municipal court judge, the biggest question I've got is, you know, why is my license suspended? I haven't even been to court yet. And then, you know, sometimes there'll be somebody be found not guilty, their license suspended for the same amount of time as somebody who was found guilty. So, yeah.
So is the administrative suspension only for refusal?
I'm gonna be honest with you. I'm not real sure where it comes from that why their license is suspended. You know, and I'm not. You know, if I can find somewhere and it explained to me why there's an administrative suspension, you know, it might be something we can work with. But I can't find anywhere in here where it's actually being suspended, other than like for the refusal. But just because somebody is pulled over and charged with the DUI, and if they don't go to court for 2 months, their license all of a sudden automatically suspended. And I don't know why.
Senator Sparks, you have some thoughts?
Thank you, Mr. Chairman. Statutorily, I think administratively as well, if someone refuses to take a properly offered test,
You talking about a breathalyzer test?
breath, blood, or urine,
Any of it.
any of the three, their license will be taken, and they have a 45-day period that they can drive. If you take the test, you have a slip of paper. It's printed out by the intoxicology machine, IP form, that gives you a 30-day permit to drive. That permit can be extended by order of the court until your court date. In the way the statute reads is if you have demanded trial prior to that 30 days passing. So that's the nature of the administrative suspension. The problem we run into, and I think it goes back to Senator Turner Ford's questions and all the commentary, is the court, the local court. You know, Oxford Municipal Court meets weekly. Tishomingo County Justice Court meets every 2 weeks. Some other courts only meet monthly, and so it could be a long period of time. What we want to do is give the judge, or recognize the judge's authority, that when they say the suspension shall start or stop, that we give credibility to that. Also, in COVID conditions and in other circumstances, sometimes you don't offer the test. And we've not even been taking some people to jail, and we're not taking their license. So are they suspended? Are they not suspended? I received a DUI. I didn't refuse the test. I didn't take the test. And so at some point, we need to go to that judicial officer and say, when does this start or when does this end? And we just want the Department of Public Safety to recognize that judge's authority. Second thing is a non-adjudication also carries a potential 120-day driver's license suspension. You can install interlock in your car if you prefer in lieu of the suspension. But no one can tell you when that suspension begins. But the order, the non-adjudication order, is signed by the judge on that day, and the judge could say, your suspension begins today. Your suspension begins, I'm going to give you 30 days to get interlock. But the court needs to be determining when the suspension starts, when it is a matter that the court should decide. And I think that's what Representative Robertson's trying to do in this bill, and I support that, and we'll get the language right with the reverse repealer. But all of these points are why we're trying to do this.
So, but this doesn't get there.
It gets us a lot
At this
closer.
point. Okay.
It gets us a lot closer.
All right. Well, I will defer to you four or anyone else that practices in this area. If y'all will get together and maybe work on some language, we can certainly either offer on the floor if you get it ready that fast, or if not, it does have a reverse appealer and I'll have to go to conference. So you can let me know what language we need to try to uphold in the conference. All right.
Thank you.
Thank y'all. All right.
I do have an amendment at the proper time.
Okay. You're recognized.
Thank you, Mr. Chairman. Under the expungement section, beginning on line 423, someone, and because we have non-adjudication today, we don't see as many cases actually go to trial, someone be found guilty. And this only deals with first offenders, only first offenders. But a first offender who submitted to the test, whether it's blood, breath, or urine, after 5 years, you've completed everything that you were ordered by the court, you can apply for expungement. Line 435 and 436 do not allow this to someone who has refused that test. I would like to strike line 435 and 436, as well as lines 437, 438, and 439, which would be an equal protection issue that anyone who's had a true first offense that has not had a subsequent DUI after the fact, they've only had one in their life, they don't have one pending, could apply for expungement and not be excluded if they happen to refuse the test or happen to blow over a certain number at the time that they receive their DUI.
And is there a period of time that they have to wait before they do that?
Currently, it's 5 years based on these criteria.
Mm-hmm.
But if you do not meet the criteria in 435, 436, and 437 through 439, you can never expunge a first offense DUI.
So my question is, if we adopt your amendment as presented just now, would there be the 5 years that they would
That's
have to
correct.
wait, or
Same
you're doing
5.
away with the?
No, sir. Same 5-year waiting period.
Okay.
Yes. And we expunge felonies after 5 years.
And these are
And this is a
misdemeanors.
misdemeanor. That's correct. And it would be your only one. That otherwise you don't qualify.
Okay, you've heard the amendment. Senator Hill.
Very good question. Two answers I'll give. One is the NCIC system, or in Jackson, where they have the same as the non-adjudication database that is confidential except for law enforcement purposes. Now, if you have waited 5 years, because you have to by statute, it would no longer be a second, because our accelerator system, enhancement system, you have to have it within 5 years. So it would still be a first, because if I had a DUI today and I had a DUI 6 years from now, that's still a first, because I'm outside of the 5-year enhancement period.
And that's current law.
That's current law. That's correct. So the only thing,
But if you had a DUI in 3 years, then to her question,
it would be a second, because I would not have been eligible to expunge it, because the 5 years for expungement had not passed.
the law enforcement would know because it's on the NCIC.
That's correct.
But what you're saying is even if it's not expunged after 5 years, when you get it, it's still first.
That's correct. And that's current law, and that's been the law for many years.
All right. Very educational. Senator Simmons.
And the same thing is for felonies. If I actually was a first time offender and I got a felony expungement, sometime way after 5 years, if I got another felony, my DA still will look at that as a first offense.
But they wouldn't be able to see it in your past through the NCIC or some form once it's expunged. I mean, there's a hidden record kept, in other words.
Yeah, at NCIC Crime Information Center,
Mm-hmm.
As it relates to DUIs, though, it is
A registry.
kept
it's a registry.
as a registry, and law enforcement can see that because they have to know on
Gotcha.
those situations.
Good questions. All right. Any other questions on that one? If not, then Senator Sparks for a motion.
I would move that we adopt the amendment.
All right. You've heard the amendments. All in favor of the Sparks amendment say aye.
Aye.
Any opposed, nay. The ayes have it. All right. Now, any other amendments, thoughts, questions, comments? If not, then Senator England for a motion. All right. You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right. 631, now there will be a strike all back to your smaller packet on this one. This one is the one that allow the off-duty use of official vehicles while performing security services. We wanted to do the strike all, and I did speak to the chairman Cockerham on the other side. This was her bill, very similar to ours, except it did not include the liability insurance requirements that we had placed into our version of the bill. So the strike all amendment puts the liability requirements, $500,000 of liability insurance, into her bill, and she actually thinks it improves the bill. I've spoken with her. She's a good legislator and friend. So we discussed this, and she actually agrees that it improves her original language. So that's what the strike all does. And Representative Cockerham, Chairman Cockerham, is in agreement with the benefits of that. So any questions about that strike all? If not,
Constitution to pass strike all, Mr. Chairman.
you've heard the motion. All in favor say aye. Any opposed, nay. The ayes have it. All right, 634. There is a strike all. This is the firearms restrictions bill that we debated. The strike all would put Senator DeBar's language back in it. And he told me earlier he's got an education meeting going on, so he wanted to be here, but is in education. But that is what it does. The strike all is the Senate DeBar language that y'all had amended here in committee. So that's the version versus what essentially was what it was without your amendments as it came to us from the House. So any questions about that? If not, Senator England for a motion. You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right. House Bill number 796. This is the habitual offender bill that came to us from the House. There is a strike all before you that was actually language submitted to us by the Prosecutors Association, and I will ask Mr. Samsel if he will to explain what the strike all version does, and then there may be, I think, an amendment I've been told about that we'll go to secondly, but I wanted you at least to know what the strike all version is first. Mr. Sampson.
Sure, yes. Thank you, Mr. Chairman. House Bill number 796 amends nonviolent habitual offenders and violent habitual offenders. For nonviolent sentencing, it defines the term within 15 years, and it had two different ways of doing that, but the prosecutors simplified that down to one definition of within 15 years. You can see that on line 16, and then how they define that term is on 22 through 25. For purposes of this section, 15 years shall be counted from the date the person successfully completed all terms and conditions of the sentence imposed by the sentencing judge for the most recent felony conviction. And then another change that the strike all did was to take out violent habitual offenders. So section 991983, that's omitted from the strike all. And then section 2 is conforming language for the parole statute. And that is pretty much what the bill does.
All right. You've heard the explanation of the strike all. Are there amendments? Senator Sparks.
Thank you, Mr. Chairman. This bill is what has commonly been referred to as the habitual bill, and I think Chairman Bain had a version that has been replaced by this strike all. We've had numerous conversations with prosecutors, and I dropped a bill on this side that dealt with habitual, which is 2556, and my amendment would be to insert the Senate language of 2556 in lieu of, or as a strike all to the strike all.
And what does it do? Can you explain it?
I certainly will. It addresses both big habitual and little habitual, which is violent and nonviolent. This was discussed at numerous occasions with prosecutors. We use a 15-year measuring period, just as they do on the nonviolent habitual, but we use that measuring period to begin where they want it to begin at completion of all points of the sentence, release from probation. We use one of two dates, either the date that you were released from incarceration. Of course, you don't get credit for the peace period or good behavior while incarcerated, or we use from the time of conviction. because if I was convicted and not incarcerated, my behavior has been good. I was not violated. Therefore, I have had a good behavior period for 15 years. So I think we're very, very close on language with that, but I prefer our language. I think it is more equitable because if someone is on probation and they got a probation sentence, they never were put into incarceration, but they violate their probation to the extent they're sent even to a technical violation center, that begins to be incarceration. And your days do not start to count until you're released. So I think it captures the spirit of when I stand before the judge. If I tell the judge I'm not going to do wrong anymore, and I maintain through my probationary period, and I do a good job, or I'm in drug court, or whatever it is, that I am in essence doing what I told the judge. So on small habitual, that's the large difference. It would also be a situation where if someone has been sentenced, and I think we try to cover this, if it's prior to the effective date, that they might be considered for parole if the conviction would have resulted in a reduced sentence if we've been convicted under the law as it currently is. So it's kind of an equal measure. As it relates to violent, big habitual, as we often call it, it has language that 9732, the code lists what are crimes of violence. And as has been discussed often in the media and even in this committee, we do not want to give someone life in prison without the possibility of parole, which is what big habitual does, for a nonviolent crime. And there are many DAs who agree with that, that for a drug possession charge that happens to be my third or subsequent felony, the state of Mississippi is not better served by locking that person up for life, day for day. So the first thing we do is that we say, unless it's listed in those crimes of violence, unless your third crime or subsequent, your triggering crime is a crime of violence, that the judge is not going to impose life. Unless we give, and this was the prosecutors asked for this, unless the judge determines your nonviolent crime was in fact violent by the nexus of events surrounding it. They already have that authority under 9732 subsection 2. So I'm fine with them doing that. But we also allow the judge, once again, we're going to give the judge discretion to make a nonviolent crime violent for the purposes of sentencing. Then we also want to give that judge discretion to say, if it's a crime of violence, the judge has heard the case or heard the plea. If he or she wants to deviate from life, that's the judge's discretion. So that's what the habitual bill that is 2556 does. I also, as a second amendment, would add a reverse repealer if that helps us with the prosecutors to sit down and go a little bit further in the negotiation table, because I believe we're really close on this.
So in your version, your amendment, give us an example of what a nonviolent crime that was committed in a violent nature, an example of what that would be.
I think that you could have a circumstance where there is an allegation potentially of an aggravated assault or a drive-by shooting or robbery with a deadly weapon, that all of those things might have been alleged, but maybe the facts are hard to prove that, but that person was in fact a felon in possession of a firearm. So the state can prove and chooses to prove, or the defendant pleads to, a possession of a firearm by a felon, which I don't believe falls under 9732, the sheer possession of it. But if the other events around it, the state wanted to put on evidence to say this was a very violent act, we just are going forward with a nonviolent charge, we would like for you to deem it violent. Then I think the judge has that authority under 9732 subsection 2. They can take any nonviolent crime and deem it violent if the facts so justify.
Okay. Questions for Senator Sparks on his amendment? Senator Simmons.
And I guess in the same example that Senator Sparks gave, in some instances, in some communities, you may have two people who would get in a car and drive by and pick up two other people who did not know or have any knowledge of anything that was about to happen before it happened. And so in the situation that he gave, if four young men were in the car and they all were charged with drive-by shooting, and drive-by shooting is a crime of violence, the prosecutor and or the judge based upon his amendment, could look at the two people, even though the prosecutor charged them higher with drive-by shooting, could, I guess, potentially look at the two that got in the car and said, well, they didn't know anything about it, and we want to try to deviate. And even though they are crimes of violence, we could put something on the record to say that the facts support the two guys that were in the back were not part of the plan or scheme to commit violence.
And is that current law, or you're
No.
saying this is the amendment?
From my understanding, the amendment will allow you to go the opposite way.
It's given the judge discretion to raise a nonviolent crime to the level of violence or choose not to sentence to life of a crime that's listed as a crime of violence, but there is no violent nexus or the fact pattern shows that you were a lesser actor. It just gives the judge discretion. Yes, that's correct.
Okay. You've heard the Senator Jackson.
I'm sorry. It would be in that's the language we prefer, because like on big habitual, if somebody, as it is now, and there are cases that everybody's familiar with, the possession of marijuana or possession of precursors has someone in prison for life. Yes, our goal would be that it is retroactive. And that's why I'm also offering a reverse repealer, because I do want to get the language right and want to make sure that the prosecutors are involved.
Okay.
Thank you.
Good question. I think I missed somebody else over here. Senator Turner Ford. Oh, sorry. Okay. Any other questions on the amendment? All right. Well, we'll take a motion.
Move to
Senator Hill, I'm sorry.
So basically, what you're doing now, the prosecutors want to look back and complete their obligations. And you're starting from like right after the front.
No, let me clarify that. I probably didn't say that well. Assuming I had a crime and I was sentenced to probation only, the maximum probation you can receive in the state of Mississippi is 5 years. And so
I think this probation or what was house arrest and incarceration.
then it would be incarceration. I'm not talking about house arrest. I agree with you, Senator, that you would be incarcerated. Your time would not begin to count until you were released from house arrest. I consider that custody.
Okay.
If that was your question, yes, I agree with you.
That's part of it. I'm assuming that probation starts at law.
That's correct, and
But house arrest would have to be after that.
that's correct. Yes,
So, as soon as they get put on probation, whatever the crime is, that start their clock ticking.
that's correct. As long as they don't violate to the extent they get sent to a technical violation center or incarcerated, because if they do either one of those things, they've erased their good behavior, and it starts upon release.
All right.
I don't know how well
We have a new commissioner. Maybe he's doing better. All right, Senator McCon.
So the only question I've got, the concern I've got right now is throughout the last 5 years, we've seen a shift holding people accountable for the payment of their fines and their payment of their reimbursement, whatever it's called. Your strikeout was in place. Very rarely do I see one that's not paid back the restitution. Thank you. Your strikeout here, you would put it from the day they were released from prison, go on probation. If they didn't pay that, which, I mean, they can violate it, they can go in jail, they're not likely to go for $1,000 restitution. Are we encouraging this behavior by going and saying from the day of conviction, instead of going to this guy here, the current strikeout is on the table, which says at the end of your conviction, pay your fines and your restitution. Are we kind of encouraging that, or are we?
Sure, fair. That's a very fair question. I think the way that this is covered is we're talking about a 15-year period, and if I only received probation, I didn't get incarcerated, one of the terms of my probation is going to be to make restitution or is going to be to pay my fines. So they're not going to get off of probation. And so they're going to have a circumstance where they're eventually going to get violated within 15 years, which means they're not going to be eligible to receive this relief. This is only going to be to people who do actually meet the obligations. And as far as someone being released from prison, the same thing would be true. They usually cannot make restitution or pay fines while incarcerated. That's why they don't get credit for the time that they're inside. They literally would start the day they walked out. They know what their requirements are, plus, more likely than not, they're on post-release supervision. And so as a term to get off of the post-release supervision is going to be to make their payments. And I do think, once again, those are good questions, but because it is a 15-year period and you're going to spend the first few years of that period on probation or parole, with the hopes of getting off of that, the only way you're going to get off of it is to cure the things that you brought up. So I don't think this encourages bad behavior at all, because it actually would motivate you to get to that beginning point in time where you can avoid being habitual. The judge is not going to discharge you in most cases if you haven't.
Yes, at the end of the day, I still see people who not receive their restitution after the person is served or gotten off parole, or they may be back. But at the end of the day, we're in a system where people aren't holding themselves accountable, so who are we to hold them accountable? And give them incentives when they're not taking advantage of. But let me ask you this: halfway houses that are in place here in West City, this would be from the date that they're released from jail, prison.
That's correct.
Not from the time they were put into a halfway house or the restitution. Correct.
The way that I would view that, and I think that's a good question as well, is if I'm incarcerated for my failure to do something that was part of my sentence, then obviously that is going to be the measuring stick. If I'm released from prison into some workforce training program, reentry court, once again, obviously I have been released. I think the clock starts, and if I violate, I'm going back, and then the clock restarts. But what we want to do is motivate good behavior, reward good behavior, and continue to penalize bad behavior. That's correct.
Senator England? Okay. Anybody else? All right. You've heard the amendment. All in favor of the amendment, say aye.
Aye.
Any opposed, nay. The ayes have it. All right. Any other comments, questions, concerns? For a motion, then, Senator Sparks on the bill.
Move that we adopt the committee strike-off as amended.
All right. You've heard the motion. All in favor, say aye. Tax sufficient to pass. As amended. Yes, as amended. All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. All right. We got two bills up. We're going to try to speed through these, but take your time and ask questions if you need to. 886. This one is not a strike call. This one, what it simply does is, currently, if you're a retired law enforcement officer, you are exempt from the fees, the permit fees for concealed firearms and renewal fees for those. What this bill does is applies that same thing to active law enforcement officers. So this bill passes, your current active law enforcement officers would be exempt from the permit fees and renewal fees for their concealed firearms. Senator Simmons?
How much money are we talking about?
The House did not send us a fiscal note on this bill, but I know do we know how much those fees are, generally speaking? Your concealed carry fees?
The renewals are $40.
$40.
And
Yeah.
how many active police officers we have in the state?
I do not know the answer to that.
Okay.
All right. But that's a good question. We can try to get an answer for you if this passes. $80 is the other fee online. The original license fee is $80. Online, $131.
So it'd be $80 times the number of officers, and that'll be how much money we'll lose annually every year.
That would be great.
Every 4 years? On that permit? Okay.
Yep. All right. Chairman Barnett.
Yes, I just want to make sure that the disabled veterans are not excluded, because I just see some underline and it just keeps referencing the law enforcement. I just want to make sure that those people will still be protected under this
Yeah, that's
current
current
version
law.
of the bill. Okay.
All right, good question. Then. Any other comments? All right, for motion, Senator England. Motion House Fish to pass. All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. And then our last bill, House Bill number 929. This is one that has come out of our Corrections Committee already. This is the reentry court for offenders. We heard the presentation on the Senator Barnett's language that we're putting in the strike all. I think y'all remember that, but if not, Ethan, can you give us a brief refresher in about 2-3 minutes of what that does? And Senator Barnett, you can correct us if we leave anything out. You can give it to us. All right, go for it.
If it's okay with you, then I would like to do a strike all.
Yeah, this is, I think we have the wrong bill in front of us. We got 949.
No, I'm looking at 929.
Yeah.
Strike off's the wrong one in the packet.
Strike all is what? I know that, but it's not. This is a different bill there. That's a whole different bill. Look at what's in the big package and not on the strike up, not on the proposed.
Okay.
Just go to the big bill, not the proposed.
All right, the last bill in your big packet. All right, go ahead, Senator Barnett.
So I would like to strike all the language from up to lines 450, I think 449, and go back to just the language from lines 450.
So you're just talking about doing section 23.
Just doing section 23, yes.
All right, and everything
Everything
before that.
23 forward.
Section 23 and 24, right. And then the effective clause.
Yes.
Okay.
And this will go back to the original language that was passed in the Senate. And this takes it back to the exact thing that the judges had agreed upon and the one that Judge Prince actually came to talk about. This would, by doing this amendment, that would take care of it.
Are you leaving the reverse repealer in there that's already in this language? Or are you taking it out?
Yes.
Take it out. Take out section 25. So you're just talking about your amendment, just leave section 23 and 24 in the bill. Is that right? All right.
Just a quick
Senator
question.
Sparks?
This would, thank you, Mr. Chairman. This would take us back to exactly Senator Barnett's bill as went through Jud B and corrections already once.
Okay.
Okay.
Good explanation. You've heard the amendment, which is an amendment from Senator Barnett. Any questions for the author? If not, you've heard the amendment. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. Any questions? If not, for Senator Simmons,
I had a friendly amendment, if it was
Okay.
okay.
you're recognized.
So on line 452, I'm sorry, 455, if we can just say the senior circuit court judge of any circuit court district, so I guess strike of the 1st, 7th, and the 15th, and put any circuit court district. When the bill was explained, when it was on the Senate side, it was that these circuits could do it only if funds was available. I raised questions on the floor. I reached out to the 4th Circuit. I talked to my circuit court judge, Judge Margaret Carey McCrae, and she said that they certainly would love to do this if they had, if they had the general law to allow them to do it. And I think Senator Turner Ford also raised that question regarding her circuit. So if no funds are going to be needed and intervention courts could do this, I'm not to the extent that they have the funds available, I think we should apply it across the state, if it's okay.
Any response, Senator Barnett? All right, you've heard the amendment. All in favor say aye. Any opposed, nay? The ayes have it. I'm sorry, I'd already called the amendment. All right, so any questions as the bill is currently amended? All right, Senator Barnett, for motion. House Future Pass Committee Sub. All in favor say aye. Any opposed, nay? The ayes have it. All right, Mr. Driver's report. Thank you, guys. You got it all done with 3 minutes to spare. Righty.